Okay, Marbury versus Madison. So Marbury is suing Madison, asking the court to issue a writ of mandamus mandating them to stamp their commissions. All right, a couple of things you need to know by way of background. The Judiciary Act of 1789, which passed when nobody really noticed. It was not deemed very consequential, really a law that nobody cared that much about, had said that the court had the power to issue writs of mandamus. We talked in class about what's another word, with the root M-A-N-D, mandatory. What that means, a writ of mandamus, is ordering someone to do something. So Marbury was asking for a writ of mandamus to be issued to Madison, ordering him to stamp their commissions. All right, what did Chief Justice Marshall, what was he thinking when he thought about this? Chief Justice Marshall was a Federalist. He would have been happy to have Federalist judges appointed and serve with him because he agreed with the political philosophy of Adams, the outgoing president. And he wanted Jefferson to issue those commissions because that would have meant more Federalist judges serving lifetime tenure in the judiciary branch. However, here's what Justice Marshall was worried about, and I call it the make me problem. What would have happened if the court, remember this was a very nascent, a young institution, if the court had said, Mr. President, you order Madison to issue those commissions. And I always say, what would have happened if Jefferson had said, make me? And the bottom line is, it would have been a constitutional crisis. We don't know how it would have been resolved. But as a matter of power, we do know that if Jefferson had refused to follow that order, what could Marshall have done? Marshall, seeing this potential, he did want a federal judiciary pact with Federalist judges, but even more than that, he wanted to protect and to embellish the power of the court. So that's where he came up with this brilliant solution that accomplished both of those objectives really, really creatively. Okay, so what Justice Marshall said is that he was afraid that if he ordered the Jefferson administration to stamp Marbury's commissions, they might not do it, which would diminish the authority of the court. I always say it's like a parent if they have a curfew and the child keeps blowing off the curfew and ignoring it, it really diminishes the authority of the parent. That's what Marshall was worried about, having the authority of the courts diminished by the Jefferson administration, ignoring it if they issued a writ of mandamus. So instead, Chief Justice Marshall looked at the Judiciary Act of 1789. The Judiciary Act of 1789 gave Congress the power to issue writs of mandamus. And we spent some time in class looking at Article 3 of the Constitution and looking at the Judiciary Act, but you don't need to know that level of detail for right now. Essentially, what Chief Justice Marshall did is he realized that if this law were not there, if he did not have the power to issue a writ of mandamus in this context, then he could say, hey, Jefferson, you should issue these writs because it's the right thing to do, but I can't force you to do that. And that's exactly what he did in Marbury versus Madison. The court struck down the Judiciary Act of 1789, and it said that this act violated the Constitution, Article 3. We looked at the language in a little more detail in class. And therefore, whenever a law violates the Constitution as interpreted by the court can strike that law down in an exercise of judicial review. So here's what we remember about Marbury versus Madison. It was the first case in which the court exercised this power of judicial review, saying, we, the court, get to interpret what Article 3 means. We interpret that language, and again, in class, you could see that he really could have gone either way. He could have said, yes, Article 3 of the Constitution would allow Congress to create a law giving the courts the power to issue writs of to issue a writ of mandamus. But, of course, he didn't want to do that. So in the very first exercise of judicial review, the court struck down the Judiciary Act of 1789 and told Marbury, sorry, Marbury, because I can't issue a writ of mandamus in light of the striking down of the Judiciary Act of 1789, I can't help you. All right, how did that fundamentally change our triangle? So now, even though the Constitution does not expressly give the judiciary the power to check other branches, in Marbury versus Madison, the court, and here again, Marbury versus Madison, the court struck down a law passed by Congress because as the court interpreted the Constitution, the law violated the Constitution. Now, this is a huge and very powerful check, and we're going to look at this more when we look at our Bill of Rights unit. But here is the core holding of Marbury versus Madison. The court has the power to say what the Constitution means. And we, in our federalism unit, we're going to look at McCulloch versus Maryland, and we're going to look at the Sebelius versus National Federation of Business case, those two cases. Those were both exercises of judicial review, where the court struck down laws. Now, in the case of Sebelius versus National Federation of Business, that was the Obamacare case, where the court upheld Obamacare as a constitutional authority of Congress's power. Essentially, Obama in 2008, he very much ran on the fact that he was going to create a health care program. At the time in 2008, he won a pretty decisive victory. There was a Democratic House and a Democratic Senate at the time in 2008. They passed Obamacare, saying that they were responding to the mandate given to them by the people. And the court, think of it, 9 unelected justices, they had the power to say, we get to determine if Congress has the power to create the Affordable Care Act or not. It is a profound check that the judiciary has on the legislative branch through looking to see whether laws are constitutional in the context of a lawsuit brought by individual parties. Second, we're going to talk about United States versus Nixon. Again, in that case, in Watergate, the court ordered President Nixon to hand over the tapes. President Nixon had said, hey, we'll give you transcripts, we'll kind of tell you roughly what was said each day, and that should be good enough. President Nixon claimed he had executive privilege allowing him to withhold the tapes. The court said, nope, you turn those tapes over to the legislative branch. And of course, that led to Nixon's resignation. Bottom line is, the judiciary exercised, again, an incredibly powerful check on the executive branch. So it is Marbury versus Madison that finally completes our diagram and gives you a good sense of that first way that the Founding Fathers made sure no branch got too powerful, the system of checks and balances.